The opinions expressed on this program represent the viewpoints of individual authors or contributors and do not necessarily reflect those of Troy University.
Hello and welcome to EconVersations. I'm your host, Dr. Dan Sutter of the Johnson Center for Political Economy at Troy University. The U.S. is a nation of laws, and laws require lawyers to write contracts, resolve disputes, and conduct court proceedings. America, in fact, has over 1.2 million licensed lawyers. All of these lawyers need training in the law, which is a task for the about 250 law schools that we have across the nation. And these law schools graduate more than 35,000 new lawyers each year. Decisions made about the law school curriculum affect our lives through the cost and availability of lawyers to help manage our affairs and write our contracts. The American Bar Association plays an enormous role in legal education through a process known as accreditation. But is the impact of all this beneficial, or may the ABA be artificially increasing the cost of law school? Joining me on EconVersations today to talk about this aspect of legal education is Dr. Alan Mendenhall, who is the Associate Dean of the Jones School of Law at Faulkner University. Alan holds a PhD in English from Auburn University and law degrees from West Virginia and Temple Universities. In addition, Alan's the Executive Director of the Blackstone and Burke Center for Law and Liberty at Faulkner University. Well, welcome to the show, Alan.
Thank you, Dan. Thank you for having me.
Well, before we get into our topic for today, I wanted to give you a chance a little bit to talk about this Center for Blackstone and Burke Center at Faulkner University, which was recently created. I think it's a very exciting center, right?
It is. It's a very exciting center. So the Blackstone and Burke Center for Law and Liberty is a research and educational institute that focuses on the common law tradition and American constitutionalism, and we examine the norms and nurture the institutions of ordered liberty. So we focus on things like economic freedom, religious liberty, freedom of speech, freedom of association, freedom of assembly, all those ancient liberties that are passed down and the Anglo-American legal tradition, and that we have inherited, and in some cases still have preserved in at least residual form.
And that's really important, because I think the common law really is like the law of liberty, the law of a voluntary ordered society, right?
It is. The common law tradition represents that bottom-up system of ordering from which we derive rules. So the idea being that rules emanate from the people, from the mores and traditions that exist that are pre-political, that are before government promulgation.
And so I think the center is helping to play a valuable part in bringing this back into the legal education.
I like to think so. I like to think so.
Well, that gets us to our main topic for today, which is some other elements of legal education. And related to this, we're going to get a number of topics today, including accreditation and professional licensing of lawyers. But to begin with, it's the American Bar Association, which maybe all of us are familiar with the term the ABA or familiar with this at some level, but we maybe don't know a lot about the details of it. The ABA is behind a lot of this, and you've recently written some pieces that were critical of some of the roles, some of the effects of ABA on legal education. So if you could, just for a preview, what are some of what you see as some of the problems here?
Well, sure. I'm happy to state some of those. I think the main problem with the accreditation regulations that the ABA implements is that they force law schools to reallocate resources toward all these expensive things, keeping technology, which takes the form of, say, computer labs. You'll see a lot of law schools with big computer labs and computers that nobody uses. There are regulations that restrict the type of work that faculty members can do, so that faculties can't go out and take paid positions with law firms or businesses, so the faculty can become distanced from the actual everyday quotidian practices of real life lawyers. So there is a tendency for law professors to grow aloof over time. But I think the most important thing the ABA does is it accredits law schools. And if you look at Milton Friedman's Capitalism and Freedom in the chapter on occupational licensure, he actually takes on the AMA, the American Medical Association, and its accreditation authority over the medical profession. And I think there's a case to be made that it's more important to protect the consumer in the medical profession than it is in the legal profession, protecting the consumer being the justification or the rationale that's always given for why we have these barriers to entry, why we have occupational licensure, why we have certification, why we require people to go to law schools and these kinds of things. And so having that power over legal education, which is the first step into the door of the profession, is a very big power to have.
Okay, so let's start to get into this because I mentioned this idea of accreditation, but if you want to be a lawyer, before you can start practicing law, you have to go to law school. And so I'm sure probably most of us have some acquaintance or some relative who's been to law school. You've been to law school, my wife went to law school, so some of us are more familiar with some of the details. But if you're not very familiar, you might not be clear of exactly what's involved with going to law school. So what's involved in the legal education process here?
Well, legal education takes 3 years of work. You have your sort of formative 1L curriculum in which you learn property and contracts and constitutional law and basic subject matter. And then in your second year, you'll still get some essential, what I would call core subjects, evidence, and maybe a secondary constitutional law class, maybe a class on the First Amendment, something like that. But then by your third year, you are taking a lot more electives. And I think there's a legitimate case to be made that the third year of law school is too much, that students are spending too much time learning things that don't prepare them to be actual lawyers out in the real world. I know right now the job market remains somewhat stagnant. It's a tough market out there for recent law school graduates. And part of the reason is that big law firms, even mid-sized law firms, are finding that their recent law grads, no matter which law schools they go to, from the top-ranked schools to the bottom-ranked schools, are just not prepared to do the everyday tasks that lawyers do. I can recall seeing new associates in law firms that would come in and they would have to ask all the paralegals, how do I do this? And the paralegals would say, this is how you do it, which really does show that the apprenticeship model does have a lot to offer it, because students are actually learning under the direction of experienced attorneys, number one, and number two, they're actually using the skills, learning the skills that they're going to use throughout their professional career. Law schools are doing certain things to try to remedy that, and they're instituting clinical work and other types of programs, but I do think it's still a deficiency in legal education that needs to be remedied.
All right, so you go to law school for 3 years, and maybe you have to be taking out a lot of loans to racking up a lot of debt pursuing law school. You go through the paper chase.
That's right.
And if you're successful, if you handle all these, especially the very taxing first year classes, you graduate, you get your law degree, but you're not quite ready to start practicing law yet, right? There's another step.
That's correct. Next, you've got to take the bar exam. And the bar exam is that prerequisite before you can take the bar. So every state administers a different bar exam. I mean, the trend is moving toward a uniform bar exam nationally, but every state controls its own admission into the practice of the bar. So in order to become a member of the bar in a particular state, you either have to pass that state's bar exam or have some sort of reciprocity agreement with another state that would enable you to waive into the state's bar. And typically, you would have to go to an ABA accredited law school if you were to want to waive into another bar, or for that matter, sit for a bar exam. To even take a bar exam in another state, you'd have to go to an ABA accredited law school.
Okay. And if you succeed in passing the bar exam, then you can get admitted to the bar, as you mentioned, and that's the actual form of occupational licensing for lawyers, right?
Correct, that's correct.
And what exactly, because even if you can't pass the bar exam, what exactly is involved with being a member of the bar, and what are you allowed to do that you couldn't otherwise? Because at some level, I mean, we're probably all familiar from TV dramas where in criminal cases, somebody's going to represent themselves, and you do have that right to represent yourself, So what exactly do you have to have this, be a member of the legal bar to be able to do in court cases?
Okay, well, one thing that's unique about the legal profession is that unlike other professions that maintain these occupational licensure schemes and that are self-regulating, the legal community sort of regulates every conceivable zone of human activity because laws and institutions fall over all human behavior. So a lawyer who passes the bar can then represent clients. You can, represent clients in any sort of context, whether it's drafting wills, contracts, appearing in court. But what makes the legal community unique is that there's unauthorized practice of law, and so the legal community can regulate who is practicing law and who isn't. It can define those parameters. So a company like LegalZoom that's trying to go in and make legal services cheap and quick and expand access to basic legal services can be deemed to be participating in the unauthorized practice of law. And so the legal community can thereby exclude those forms of competition. So really, the bar exam makes sure that there's a monopoly on legal services and that anti-competitive practices get enshrined in our institutions and our laws.
And so it's really sort of like the representation of other individuals in court that's at the heart of this monopoly?
It could be in court and it could be outside of court. It could be in it could be just in interactions between businesses. Lysander Spooner, a 19th century libertarian philosopher, believed that that legislating these barriers to entry for lawyers was an infringement on the freedom of contract, because he thought, hey, if you and I want to contract with each other, you know a lot more about the law than I do. So I want to say, hey, Dan, can you help me with this contract? Can you help me? Because you're good at that, then we should be able to do that. We should be able to have that freedom. But these legislative impositions prevent us from having that voluntary transaction and from having what really would be mutually beneficial exchange for both of us. So I think that's one major problem with bar exams and licensure on sort of a philosophical level.
Okay, so then we said there are requirements for sitting for this bar examination. And if you can pass the bar exam, there are some other things you have to do to be able to become a member of the bar. There's like a background check and some other things. But basically, you have to pass the bar exam, but then you have to also be legally able to sit for the bar exam. And that's where the accreditation story comes into this, right? Because you've hinted at this idea that you have to, in some states, you have to attend an ABA accredited law school to be able to sit for the bar exam. So we've used this term accreditation, but I think we should probably explain it a little bit more, because it is something that occurs a lot in higher education, but if you're not involved in higher education, you're probably not familiar with it. So what is this, what do we mean by accreditation in higher education?
Okay, accreditation is basically permission to, or it's a certification, it's a form of authorization that shows a stamp of government approval, in this case the Department of Education with the ABA. So just to back up a minute, explain what the ABA is. The ABA is a nonprofit organization incorporated in Illinois that operates as a trade union for lawyers, essentially. And more to the benefit of law professors than lawyers, actually, but that's the theory behind it. Now, since 1952, the ABA has enjoyed accreditation and powers from the authorized by the Department of Education. And it's actually there's kind of an ugly history behind the ABA's barrier to entry, which is that when the ABA was first formed by sort of an elite fraternity of men on the East Coast, it was formed to prevent low-income people from entering into the legal profession, and in particular ethnic minorities from entering into the legal profession. In fact, in 1912, it came out that 3 African Americans had become members of the ABA, and several members of the ABA panicked and they ousted those 3 members, prompting protests by the NAACP. And in fact, that same year, the ABA passed a resolution stating that it was never contemplated that our organization would admit members of the colored race or something to that effect. And for 66 years, the ABA excluded black people from membership. Now, since then, of course, the ABA has done all kinds of things to promote diversity and champion different forms of diversity, both racial, gender, sexual orientation, all these kinds of things. But I think you can't turn something that by its very function is to exclude people into something else. So a lot of the ABA accreditation standards and even bar examinations, which are administered by state bar associations, have the disproportionate effect on ethnic minorities, on low-income people, on people that are really trying to dig themselves out of poverty or change their circumstances. And so it's really unfortunate that we haven't invested so much power in these institutions.
So you think of the 250 or so law schools in the country, if I think I remember correctly, there's about 206 of them are actually accredited by the American Bar Association. So how is it that, and I think there's around 15 or so states where you have to actually graduate from a ABA accredited law school to be able to sit for the bar exam. How would a provision like that get imposed?
Okay, that's a really important point because it shows the distinction between what the ABA is and what a state bar association is. So what a state bar association is a corporation that the legislature has granted monopoly powers over the practice of law, and that is superintended by state Supreme Courts. So it is the State Bar Association and the State Supreme Court that together determine who is and who is not eligible to sit for the bar exam. And typically, that requirement will be that you must graduate from an ABA accredited law school. In fact, all states recognize ABA accreditation and will let you sit for their bar if you pass. If you graduate from an ABA accredited law school. Now here in Alabama, we have two non-ABA accredited schools, Miles and Birmingham, and you can sit for the bar in Alabama if you graduate from one of those schools. And a lot of schools have this. California has probably 20-something unaccredited law schools that will enable you to sit for a bar exam in the state of California, but you won't get that reciprocity. You won't get that reciprocity that would allow you to practice law in another state or to even sit for a bar exam in another state, typically.
So just to be clear, this accreditation function means the ABA doesn't run any of these law schools, right? They are run by, I guess they're, most are affiliated with a university, but as we were talking earlier, they're actually independent of the universities, right? Yeah, governance from law schools is autonomous from universities to a large extent because of largely because of ABA regulations. Okay, and the ABA doesn't have a complete monopoly over the ability of anybody to open a law school. We do have these non-ABA accredited law schools, so it's not like they can ban somebody from organizing a law school. Right?
That's correct. That's correct.
Okay, so we have this combination of, it's sort of really like the combination of the law school or the occupational licensing and the accreditation that's giving the ABA some power. But if we think about this for a second, wouldn't there have to be something like this, a whole accreditation and licensing process, even if we didn't have our current system as it is? Because if I was running a law firm and I was looking to hire somebody to work with clients, and you came to me and applied for the job and said you had knowledge of the law, I probably wouldn't want to take your word for it. Right, I'd probably want to see some evidence that you had, and even if you went to, say, some law school, I'd want to have some assurance that they were actually teaching the law there at the law school you went to, as opposed to, our students have run-ins with the law, so they're very knowledgeable about the law, right? So there would have to be something similar to what we see going on here, even if there was a complete market with none of this licensing involved, right?
Yeah, so let's pretend that the ABA did not have accrediting powers, and let's pretend that there were no bar associations that enforce these barriers to entry. And let's even assume that there were no bar exams. Still, there would probably be some form of law school, some form of legal education, because there has to be a method for, as you say, testing people's skills. Now, it could be, as I mentioned earlier, the apprenticeship model. That could be a viable model as well. But this idea that if you were to take all those things away, there wouldn't be law schools, I think is false. I think the biggest law firms would still hire from Harvard and Yale and Chicago and Stanford. You know, you would still have ways of distinguishing ability that were separate from what we just talked about. And with the bar exam in particular, the bar exam doesn't test how to practice law. It doesn't test practical skills. So by removing the bar exam, taking the bar exam out of the picture, you would have no measurable effect on basic skills, basic, talent that it takes to practice the bar. To practice law.
I think this is an important point to get into, because it's closely related to the issue you raised about the cost of law school, and that is when you're talking about trying to verify the quality of any type of education or training or skills and so forth. Higher quality always involves higher costs. Or the more training the more time somebody's going to take to train or learn about the law, the more costly it's going to be. And there's always got to be a trade-off between the value of the quality of training and the cost that's imposed there. But there can be a lot of elements of the training that aren't actually adding a lot of value to it, right?
I think that's absolutely right. Yeah, I think one thing about ABA regulations, I mentioned earlier that it forces law schools to reallocate resources toward a lot of things that drive up the costs of legal education. And these are costs that eventually get passed on to consumers because just the extraordinary amount of fees that are involved in all these, that law firms are having to dig their associates out of debt, and they're having to and the students themselves are having to dig their way out of debt, and of course that only incentivizes tightening those barriers to entry and controlling who can come in and who can come out, because then you can ensure that you can keep those prices high so that you're trying to pay off. But it's a vicious cycle, because the more you do that, the more the law schools are able to, the law schools and the ABA are keeping the prices keep going up, and everything just keeps going up. And this is all coming at the expense of just the everyday consumer who can't afford basic legal services.
And one thing you suggest is the possibility that you could easily have perhaps a 2-year, that maybe law school only had to be 2 years, possibly even just 1 year if you want to focus more in on the train, on maybe move to more of an apprentice-based system where 1 year would be law school and then apprentice after that. So if we get into this then, like when you look at that third year of law school, you mentioned before, but maybe we get into some more of the details, that a lot of the classes in the third year of law school aren't very closely related to the actual practice of law, right?
That's true, and I've actually always thought that it would be neat to do something like what medical schools do, where they have an MD, PhD track. And say you want to be a practitioner, you go out and you get what used to be an LLB. The law degrees used to be an LLB. And you could go out and you could do that. Let's say it was a year and a half of school. And then you could go out in some sort of apprenticeship model that would maybe even take the place of the bar exam. And then there would be a separate track for people that wanted to be academics, for people who wanted to research the history of law or the philosophies of law, jurisprudence, or focus on constitutional law and appellate work. Those people could go on the JD track. It would be like that MD, PhD distinction, but in the law it could be an LLB, JD distinction, so that there are people who have an academic curiosity and an academic interest in the law, and there can be a track for those people. And they can go on to be law professors or faculty in whatever department might have an interest in legal-related analysis. But then all the people that just want to go out and be practicing lawyers, who don't want to deal with all those theoretical courses and don't want to take the writing requirement where you have to write a law review length piece and all, they can go and take the courses they need to take in order to get out and start filing lawsuits and start handling cases and start helping the needs of people that have those needs.
And again, to get into some of the detail, or a couple more details here of this. You mentioned the fact that in law school you don't necessarily learn a lot about how to actually do some of these mechanical things. In the case of the law school graduate who's passed the bar exam, but they have to ask the paralegal who's never been to law school how to actually do things like write a brief or file file some documents, right?
That's correct. Yeah, I mean, there's a long learning curve. Because what you're essentially doing in law school is you're delaying people's lives 3 years. You're delaying their job, their occupation 3 years. And then once they enter, assuming they've passed the bar exam and they've gone through that hurdle, then they've got another 3 years of a learning curve. So it will take basically 6 years for somebody to get comfortable in their own shoes practicing law. And that's just so long. And it could be shortened, and it would really help both prospective lawyers and young attorneys, and I think society generally, to have people more equipped earlier rather than just delaying and essentially forcing out a lot of people that would want to go to law school. I mean, there are people that just don't have the money and the income, and they don't have people that can support them and help them get through 3 years of law school. And so you're not just excluding people through all these hurdles that we talked about, the bar exam and all these things, but you're excluding them based on just financial means alone.
Now, we've been talking about the two issues of accreditation and then occupational licensing. And to make the point that it's the two in combination that are leading to a lot of things here, you offered in something you wrote recently some examples from journalism accreditation where there is no occupational licensing, and a couple of the leading journalism schools in the country actually have recently dropped their specialized accreditation, right?
That's right, yeah. Northwestern and Berkeley both just dropped their accreditors and said, you know what, this is not worth it to us. It costs too much money to comply with all these regulations, which are archaic for our field, and we don't need it. We're Berkeley and Northwestern. Are people going to devalue our degree because we didn't get accredited? No, let's just forget this accreditation stuff. And I've actually encouraged leading law schools to do the same thing. The difference is that because we have all these state requirements established by the state bar associations and state Supreme Courts that require you to graduate from an ABA accredited law school in order to sit for the bar, it makes it it disincentivizes big schools from doing something like that. However, we could try to encourage state bar associations and state state Supreme Courts to look into this a little more and start considering, well, maybe if several states got the idea that we don't need this ABA accreditation or that this ABA accreditation is harmful, maybe we could start pushing back in that form.
Well, and just to wrap up, I want to mention one other thing that this whole element of accreditation is affecting. That's individuals who've learned the law in other countries, and I mean to come here in the United States, they can find it difficult to start practicing here, right?
Absolutely. There is a law school in South Korea called Handong Law School, and for a time their graduates could sit for the Alabama bar, and they can no longer sit for that bar. But there are some very capable graduates of that school who are practicing law in Alabama and doing very well. And in fact, there's one in particular, attorney at Beasley Allen Law Firm, who does a great job. He's very well known, very kind person, and prominent member of the bar. And so the students graduating from these law schools are very able. They're the kinds of lawyers that we would want to be members of our bar, but they're unable to.
Well, thanks very much for coming on and talking about this today.
Thank you, Dan.
And thanks for joining us. So join us again next time for another EconVersations.